We'd like to go ahead and start our lunch presentation. I'd first like to introduce Christina Hussar, who is the Symposium editor with the Journal of Law, Economics, and Policy. She's going to say a few words about the JLEP as well as about the Mercatus Center.
Thank you, Erin. As she said, I'm Christina Hussar. I'm actually here, I'm wearing a couple of hats today. I'm here obviously as the editor of the Symposium of the Journal of Law, Economics, and Policy, and I can speak on their behalf to say that we are absolutely thrilled to have the opportunity to publish the works that are being discussed today in a special symposium edition, which should be available early fall. That is our target right now, and we do hope that you will eagerly subscribe to JLEP so that you can get those editions. I'm also here as a student at George Mason University School of Law. I'm going into my fourth year. I'm an evening student. I didn't fail. So I've got one more year to go, but I've really enjoyed the study of law and economics, or rather the application of economics to law and to policy. I always say I do well in this school because that's the way I kind of think naturally, so it fits right in. Lucky me that I went to George Mason. But I am also listening to the presentations, that framework. Finally, I'm also representing my day job here, which I should mention since I'm here on the work hours, which is I'm a professional staff member of the Subcommittee on Regulatory Affairs. You may or may not have heard of us, but we are a subcommittee within the Government Reform House Committee, and what we do is primarily oversight. Anything that has to do with regulations, we're able to take a closer look at, to generate some discussion, and kind of prompt the committees of jurisdiction to take action. We also have oversight over the Paperwork Reduction Act, which is pretty much the only piece of legislation that we can amend. But the goal of that act is to reduce paperwork burden. So if anybody has specialized areas of expertise in that, we can talk. So basically, I wanted to kind of give you that perspective of who I am and why I'm here, and I am definitely paying attention under all those different roles to what is being said, and I would certainly encourage any recommendations that you all have about how Congress can be more influential on this topic. I think they've been dormant on issues of e-commerce, and I'd like to, like I said, take a little more of an intellectual look at it, but also bring in some of the distinguished folks that we have here today and educate some members of Congress and see how we might be able to be useful. As I said, I'm with the Journal. I did want to point out one of our staffers has already left today, but Jamie Belcour was the young lady that was videotaping you all, and I wanted to thank her for her efforts. And Jeremy Kidd is actually in the back of the room. He is our executive editor, and he's been signing people in and will be taking over the duties of filming. But I wanted to thank Jeremy and thank Jamie for their efforts, and all the other members of the Journal that are going to be editing and spading all their assignments. So go easy on them. Hopefully you all have good footnotes. Finally, I would like to say a little bit about the Mercatus Center, which is I think an excellent branch and represents the university very well. Like I said, I work in regulation, so frequently I will refer to research that the Mercatus Center has done, and I know it's used widely on the Hill. Like I said, I'm a little biased. I do go here for law school, but I wanted to commend them for their efforts. And it doesn't surprise me at all that Mercatus has put together this this symposium, and obviously we're grateful for my JLEP hat, grateful to be able to participate and to publish the work. But this is a cutting edge issue. And the fact that Mercatus dug it out and said this is something that we need to focus on and develop scholarship on, that's what Mercatus does. That's the role they fill, and it's very much appreciated. So with that, I would like to turn it over to Susan Dudley, who is somebody I've worked with very closely in, again, my capacity as a student, in my capacity as a editor on JLEP, and in my role at work. But Susan is the director of the Regulatory Studies program here at Mercatus. And I will let her take over. Thank you.
Well, yes, Christina, she's someone
to send those birthday cards to. Tell us when your birthday is. Christina's a rising star, I can tell you that from having her in my classes and working with her. Let me also just make a couple thank yous because they're here now and they may not be later. Erin Email, who you've seen several times up here, and Colleen Moretta, who you haven't seen but who behind the scenes has done an awful lot to get this ready, both from Mercatus. Thank you for our delicious lunch and everything else. And now let me introduce our lunch speaker, Michael Grieva. He's the John G. Searle Scholar at American Enterprise Institute and Director of the Federalism Project. So you can see where the tie-in is coming in here. His research and writing cover American federalism, its legal, political, and economic dimensions. He earned a PhD in government from Cornell University. I won't give away the year, but he's a lot younger than I am. And so a little bit different because he's got a PhD in government rather than the economics and the law that we've been hearing, but trust me, he's got both of those. He's currently working on a book on the constitutional foundations of competitive federalism and editing with Richard Epstein a volume on the law and economics of federal preemption. So all these issues are very relevant for today's discussion. Now, in your pamphlet, we have, he's giving us a different talk than he said, and I think it's because he heard Ken Starr's call to arms this morning on, and he didn't, but he must have heard it on the Dormant Commerce Clause, because his new title is The Dormant Commerce Clause as an Ex-Ante Rule. And I gather we'll have, if you're interested in copies, that's something we'll be able to give you, not today, but later. So.
Oops. Thank you, Susan, and thank you all. I'm honored to be here. I assure you that before I changed the title of my talk and the topic, I did actually get pre-clearance from Tatsubuki. So I'm doing this by permission. Here's what I want to do. In the New York and Michigan wine cases, the Supreme Court reaffirmed, albeit without explicitly discussing, the existence of a dormant commerce clause in the form of an anti-discrimination rule. As you heard this morning, justices and some legal scholars have expressed a lot of dissatisfaction with the Dormant Commerce Clause, with its interpretation as an anti-discrimination rule, and with what they view as the meandering course of the Supreme Court's case law. The clause, they say, is not actually in the Constitution. It's a debatable inference at best and a wholesale judicial invention at worst. The anti-discrimination principle has been criticized as excessively broad and under-inclusive at once, and the Supreme Court's decisions are said to be inconsistent and maybe incoherent. Now, my own sense is that so far as constitutional inferences go, the Dormant Commerce Clause is actually about as good as it gets. And my own sense is also that the Supreme Court's decision over the past years are on the whole no more erratic than the court's case law on, say, federal preemption or equal protection. But I can't hope to settle these debates in a luncheon address, and so I'll adopt the time-honored topic of changing the subject, or at least the perspective. Here's my suggestion. Say what you will about the derivation of the Dormant Commerce Clause and its adjudication by the Supreme Court. If you look at it from a Buchananite constitutional choice position, Buchananite as in James Buchanan, if you look at the constitutional rules from an ex-ante position, the anti-discrimination rule is probably the rule that prospective citizens of a federal republic would choose. There are very good reasons to think that the rule would beat any available alternative in any pairwise comparison. Now, since there is some doubt as to whether the Supreme Court has actually articulated a rule here, I think I should articulate what I take the rule to be. The essential meaning of the Dormant Commerce Clause, the Supreme Court has said, is that no state may treat in-state economic participants differently, meaning better, than out-of-state actors. The clearest violations are statutes that facially discriminate between in-state and out-of-state commerce, as in the wine cases, but the prohibition also extends to facially neutral state measures that constitute intentional discrimination. Like other anti-discrimination rules, the Dormant Commerce Clause principle is then surrounded by second-order rules to control against over-inclusiveness on the one side and evasion on the other. First, the rule permits permits discriminatory state laws where no other non-discriminatory means are available to protect a legitimate state interest. You can understand that exception in analogy to what is called the operational necessity defense in equal protection law. Generally, you can't segregate people, but you can segregate them in prisons to prevent race riots, and so that's permitted. That's called an operational necessity defense, and the exceptions under the Dormant Commerce Clause work just like that. Second, the anti-discrimination principle is buttressed by anti-sham rules to protect against brazen evasions of the core principle. The most important of these anti-sham rules is the bar against state laws that discriminate in purpose or effect. I also understand the balancing test of Pike versus Church fame and the combined effects doctrine of Westland Creamery versus Healy in that supportive fashion. So understood, the Dormant Commerce Clause is preferable ex ante, I think, to the following alternatives. First, no judicially enforceable general constitutional limitation to state regulation at all. Second, a generalized judicial balancing test. And three, more restrictive alternatives, such as an exclusive interstate commerce clause, which was the prevailing understanding during the 19th century here, or an origin principle, which is the European model. And I'll consider these alternatives in turn. So first, no judicially enforceable rules at all. It's been argued that the Constitution needs no dormant commerce clause. Ex ante, citizens will, of course, want to protect themselves against protectionism and discriminatory state legislation for substantially the same reasons that they want free exit and entry into and out of the various states. They look to the global gains of the federal arrangement, which can be procured only if the states surrender their parochial opportunistic gains that might be had from mutual aggression. But the citizens may want to block the defection by political rather than judicial means. The protection on that against discriminatory state legislation on that view can be left to the Congress, acting under the Supremacy Clause and its copious enumerated powers. The principal, and to my mind decisive objection to that position, is that we neither have nor want a federal government with the requisite monitoring and policing capacity. We have a very fragmented, lumbering government because we fear that the output of a more cohesive system would consist chiefly of faction-driven dross and only rarely of public regarding legislation. Sacrificing a few good laws, Hamilton said, seems a small price to pay for preventing a flood of bad ones. But the calculus changes with respect to those subsets of state action that we know in advance to cause more harm than good. And here the general strength of our system, the impediments to prompt energetic federal intervention, turn into a weakness. You can't get a handle on that problem by adjusting the federal legislative equilibrium across the board, because less of one risk invariably means more of the other. And what the Constitution does for that reason is it designates specific forms of state legislation for special treatment. And those state laws are now listed in Article 1, Section 10, which subjects some forms of state legislation, impairments of the obligation of contract, debtor relief laws, ex post facto laws, treaties among states and foreign nations, to an absolute prohibition. Article 1, Section 10 subjects other state laws to a qualified prohibition. No state law without congressional consent. And state laws subject to that proviso include duties on imports and exports, duties of tonnage, the maintenance of standing armies in times of peace, and state compacts. At the time, that arrangement was called a negative, as a negative commerce clause. State laws turn into pumpkins when Congress does nothing. Now note that all of these, virtually all of these quote-unquote suspect classes of state legislation have very pronounced state external effects. Ex ante, everyone would be better off if no state were allowed to engage in the prohibited behavior. Ex post, individual states, by popular or by interest group demands, are highly likely to defect and to invite comparable defections by other states. And since the ordinary operation of the federal legislative process is unlikely to provide an effective remedy, the Constitution addresses that political risk by reversing the legislative default rule. Ordinary state enactments take force until and unless Congress says no. These suspect laws, those are predictable, that have predictable and predictably bad external effects, take effect only if and when Congress says yes, so that the proponents of these state laws have to win twice, first in the states and then in the federal arena. Now, obviously, the Dormant Commerce Clause differs from the constitutional prohibitions in its institutional configuration. It's the court, rather than the Congress, that serves as the first line of defense against suspect state legislation. And of course, the court performs that function in the ordinary fashion of deciding cases and controversies. It doesn't sit as a general review and approval board. And as a matter of constitutional interpretation, you can certainly argue that the special constitutional treatment of some classes of state laws, imports, exports, and so forth, implies that all other laws, state laws, should receive the ordinary treatment. The interests that are protected by the Dormant Commerce Clause are constitutionally protected by the Import-Export Clause, the Privileges and Immunities Clause, and perhaps a general constitutional prohibition against extraterritorial state legislation. And beyond those bounds, the argument runs federal preemption. Not some made-up judicial inference is the proper remedy. But as I said at the outset, my question today is not what rule is actually in the Constitution, but rather what constitutional choices prospective citizens would make ex ante. And on that score, I think the best bet is that the individuals will prefer constitutional protection against state exploitation enforced judicially or through congressional consent requirement to no special rule at all. And they will do so for precisely the reasons that animate the textually specified injunctions in Article 1, Section 10. Now, next item. Granted that we need some special protection against state protectionism and mutual exploitation, why, you could ask, should that take the form of an anti-discrimination rule? After all, some forms of discrimination, or state discrimination, are okay. Direct state subsidies are an example. Conversely, some forms of non-discriminatory state legislation have nonetheless been held to violate the Dormant Commerce Clause. Similarly, it appears that the Dormant Commerce Clause has been invoked as a protection against political risks, such as interstate trade wars, while other decisions have emphasized the threat to economic union. Perhaps those risks run in tandem much of the time, but they don't always do that. And most fundamentally, the Dormant Commerce Clause implicates incommensurate constitutional interests. The interest in local self-government over some range, and the economic interest in procuring gains from cooperation. Now, if you look at all this stuff in the federalism portfolio, maybe we should look for some sort of efficient frontier here, and maybe a simplistic screen test, discrimination yay or nay, may ill-suit that purpose. So why not have an all-encompassing balancing test under the Dormant Commerce Clause, which would presumably acknowledge state discrimination as a factor, but without making everything hang on that question? In other words, what's wrong with Felix Frankfurter's Dormant Commerce Clause, which was a comprehensive balancing test? And the answer, it seems to me, has not to do with the Dormant Commerce Clause itself, but with a broader argument about the invariable trade-offs between rules and standards. You always trade the risk of under and over-inclusiveness against the risk of possibly more accurate, but also less predictable standards and balancing tests. And I admit to a general preference for rules. That preference strikes me as particularly compelling when the choice concerns not the application or interpretation of pre-existing rules, but rather the choice of the rules themselves. At a constitutional choice level, the option for balancing is an option for brutal, unconstrained, baseline-less choice by whoever is authorized to make it. That is the point of the modern progressive's constitution. Everything is up for grabs. There is no baseline, Cass Sunstein says. And now that Stalinism has entered the choice set, let's be pragmatists and have cost-benefit analysis. I concede that it may be that Professor Sunstein might do a better job at the federalism frontier than political institutions or than the Supreme Court under some general rule. But it seems to me the basic constitutional choice is not to optimize the results given beneficent and sensible rulers. It is to restrict the range of equilibrium outcomes given a pathological political process and non-Herculean judges. And for that reason, I think a balancing test is not a plausible choice. Let me move to more restrictive alternatives than the anti-discrimination rule. The anti-discrimination rule is arguably underprotective. For example, there are obvious benefits to a rule that bars states from defecting from an interstate equilibrium that yields substantial network efficiencies. But those kinds of defections are only poorly described as discrimination. Another set of problems is exemplified by a case called Exxon versus Maryland, where Maryland barred petroleum refiners and producers from operating gas stations in the state. And the Supreme Court in that case decided that the statute discriminated neither against interstate commerce, only among different kinds of out-of-state suppliers, nor between in-state and out-of-state competitors, because Maryland had no refiners or producers at that time. But arguably, that statute is the kind of state interference with interstate commercial transactions that ought to be barred. And one way of accomplishing that result and to deal with the kinds of issues that I just sketched is an exclusivity rule. That is to say, a rule to the effect that the state's external commerce, as opposed to their purely internal commerce, is inherently and exclusively in the federal domain. That exclusivity rule prevailed for much of the 19th century in the United States, and the rule has very much to commend it, to my mind, but it also has two problems. The first is textual, which is the constitutional text and structure cut against an exclusive commerce clause when and where the framers sought to exclude concurrent state authority. They generally said so, and when they didn't say so, then it seems they didn't mean it. Second, and more important for my purposes, in a federal system, an exclusive commerce power presupposes something that is not exclusively federal. Otherwise, everything would be exclusively federal. And that something, presumably, is the internal commerce of the states. Now, that distinction and assignment of authority, external goes to the feds, internal goes to the states, is fundamental to all constitutional choice models of competitive or market-preserving federalism, and it's easy to see the intuitive appeal there. The glitch is the history of the external-internal distinction is not a happy one. The principal example, as it happens, is that of the wine cases, booze. Alcohol regulation was the origin of what was called the original package doctrine. And I take it, which held that so long as the stuff is in its original package, it's in interstate commerce. Once it's broken up, it's in in-state commerce. And I take it that no one hankers for the return of that doctrine because it was not a very good one. Among other problems, it really had nothing to say about stuff that never made it into an original package, such as steam engines or pianos. But an otherwise sensible Supreme Court thought that it needed the doctrine because there had to be some line that separates exclusive powers on either side of the state-federal line. But as it turned out, the original package doctrine provided neither legal nor political stability, and similar doctrines that served the same purpose, such as the distinction between property and commerce, or between direct and indirect regulation, have not done much better. The history of the Dormant Commerce Clause over the past 7 decades can be understood as a sustained effort to move away from exclusivity to anti-discrimination, from subject matter limitation to anti-discrimination as a basic principle. I cannot think of very much else that has gone right in constitutional law over the relevant time frame, but this particular doctrinal trend strikes me as salutary. Not for any reasons of inherent legal logic, but for pragmatic reasons. A modern economy will bring enormous pressure on an external-internal distinction, far more pressure, I think, than the distinction can bear. James Madison suspected as much, and I think history has proven him right. But even in a sea of, and especially in a sea of concurrent powers, which is then what you're dealing with, the political risks that the exclusivity doctrines were supposed to deal with still remain, and an anti-discrimination principle is the best way, or at least one superior way, of addressing them. I should parenthetically note that the hard conceptual question, which I'll promptly sidestep here in the interest of time, is that it is very hard to have a dormant commerce clause without some sort of notion of exclusivity. I'd be happy to answer questions about that. I doubt that my answers will be much better than anybody else's, but I'll postpone that for the Q&A and move to the final constitutional choice option, and then I'll conclude. The United States is not alone in confronting the problem of harmonizing, as it were, state government with free trade principles. Europe has also confronted that problem, and as it turns out, the European Union acquired its own version of the Dormant Commerce Clause precisely in the same way we acquired ours, namely by judicial invention. But the European version is much bolder in two respects. First, our Constitution actually has a supremacy clause. The European treaties did not and do not, and therefore the European Court of Justice made it up. Second, the European Court of Justice regime is much more draconian than our anti-discrimination rule, at least with respect to the sale of goods. EU member states may not interfere with the marketing or sales of goods, not even by non-discriminatory means, provided only that those articles conform and comply with the law of their country of origin. From a free trade perspective, the so-called origin principle, which is a close cousin of our Delaware principle of contractual choice in corporate law, has some advantages over a mere anti-discrimination rule. First, it has much greater potential to break down qualitative trade restrictions, that is to say regulatory barriers that function as the equivalent of tariffs. That's because the origin principle is sort of a contract regime in disguise. The producer's home state rules just travel with the product. And second, the origin principle, unlike an anti-discrimination rule, generates enormous taboo competitive effects on the producer side, because the producers will just migrate to the jurisdiction that offers the law that is preferred by most customers. Those are the advantages, but again, there are two objections. First, the origin principle has truly radical effects. On the consumption side, it produces sort of a kind of forced entry by the producers of foreign goods and services on their home terms. On the production side, the principle unleashes, at least in theory, as I just said, rapid and pervasive factor mobility. Now, those features are probably worth having when the constitutional task at hand is to break down entrenched parochial regimes in a real hurry. That's precisely why the ECJ adopted the rule. But it's not at all clear to me that that is the best ex-ante choice for citizens under all sets of assumptions. The point of constitutional choice is to ensure political stability. And while it's hard to tell how much stability is enough and how much is too much, it's plausible to think that citizens ex-ante might prefer a little more stability than the origin principle would arguably or likely permit. Second, and to my mind more decisively, the origin principle is very hard to justify as a constitutional choice, as opposed to a policy choice. Its economic justification, the global gains from free trade, hold up only over the range in which contracts promise to work well and without significant third-party effects and externalities. Even ardent defenders of our corporate law model, like Roberto Romano, doubt whether their model would work when it comes to regulating, for example, brokerage houses. I myself am much more bullish than Roberta, or maybe more heedless on that particular issue, but even my enthusiasm wanes when it comes to, say, antitrust law. The notion that conspirators should be able to choose their own jurisdiction and then reap the rents in all sister jurisdictions has, to my mind, very little to commend it. I think Parker versus Brown is an utter disgrace and not a model of federalism. Regulatory economists, of course, disagree about the conditions under which the origin principle will prove efficient or, more modestly, superior to a centralized regime. But even if we were more confident there than, in fact, we are, I think it would be unwise to write a limited range principle into a constitution. Our Constitution fails to spell out the precise scope and content of anti-discrimination norms. It doesn't say what full faith and credit means. It doesn't say what privileges and immunities are. And that is not, as originalists sometimes say, because everybody understood what they meant. It's because everybody understood that misplaced concreteness and specificity is fatal to a constitutional order and stability. It's true that every general non-discrimination principle will have to make exceptions and adjustments down the road. None of them are self-explanatory. But an origin principle would have to specify its own range, its own limited range of application in the Constitution itself. And that's not an attractive choice because it presumes far too much knowledge about a messy, contingent, and changing world. Let me say a few concluding words. In suggesting that a general anti-discrimination rule against state protectionism and exploitation is a sensible constitutional choice, it turns out I find myself in very good company. When he was asked to speak to a European audience on America's constitutional lessons for Europe, Justice Scalia started on a very different note, predictably different. There may be no such lessons, he said, and in any event, he would not be the person who would deliver them to the Europeans. Justice Scalia often reminds his audiences, I am not an Italian jurist, I am an American jurist. And he's not about to give advice, unsolicited advice. And still, he urged the Europeans on that occasion to do themselves a favor and write a dormant commerce clause into their legal instruments. Turns out even Justice Scalia likes the dormant clause. He just doesn't like it enough to make it up. As I cautioned at the outset, the constitutional choice argument does not really answer to that charge, which is that the dormant commerce clause is not the choice that our Constitution actually made. Nor, I fear, have I done much to dissuade critics who view the existing dormant commerce clause as incoherent. And I very much doubt that even a better developed version of my argument would persuade either of these camps, but I'll say this much in defense of the constitutional choice perspective. It suggests very strongly, and I believe correctly, that the principal constitutional design problem you have at this front is not the scope and shape of a dormant commerce clause. The anti-discrimination principle there serves its purposes well enough, and if the charge is, well, it's inconsistent, the reply is inconsistent compared to what? The design problem, I think, is the positive commerce clause and its exercise. Here's what I mean. Nobody, well, sorry, let me take one step back. I do believe you cannot make a federal order work without something like the dormant commerce clause. The judiciary has to play some role here. But on the other hand, nobody wants the judiciary to superintend the nation's commerce on an ongoing basis. And that's because the interventions will be sporadic and the rules against state infractions will be systematically under-enforced. And moreover, the equal treatment formulations and formalisms may backfire. The Supreme Court cannot really liberate interstate wine markets on its own. All it can do is to hold in-state vintners hostage to the anti-discrimination rule, and when the state then decides to shoot the hostages, the game is up. One way or the other, the federal political process then will have to do much of the work in protecting interstate commerce against state infractions. The constitutional design task, therefore, is to figure out political, institutional arrangements that will tend to affirm and extend ex-ante preferences with some modicum of regularity. And there, I submit, is the real failure. Sometimes Congress entrenches state cartels that would otherwise collapse economically or by force of the dormant commerce clause, witness insurance. At other times, Congress does bestir itself to break down state barriers, but only by means of creating national regulatory cartels. Harmonization and not free trade is the default outcome. We have a commerce clause because we need it, and yet we have found no way of ensuring that that power will actually be put to the purposes for which it is intended. Compared to that constitutional choice dilemma, the dormant commerce clause is easy. Thank you.
Michael, this may have been the question you were hoping to duck. But it seems like if you move from the exclusivity regime to the alternative regime, it seems like the danger is the worst of all worlds, which is the ability of both the feds and the state to regulate. duplicative, double layers of regulation. Doesn't the exclusivity principle at least leave us with only one Leviathan to pound on us?
Yes. No, look, that's not the only. I mean, that's one obvious practical political difficulty, right? Once you live in a world of concurrent powers, the legal regimes start being redundant in the worst of all senses, namely, I mean, the interest groups just migrate from, you know, from one opportunity point to the next, right? And one branch of government is always open for business. That is not a happy situation, and the point of the exclusivity doctrine is precisely to demarcate the lines, excuse me, and to forestall that kind of a scenario. That's the huge attraction of the exclusivity doctrine. The difficulty is, for the life of me, I cannot see how that, I mean, how you can reconstruct a dormant, a Commerce Clause doctrine on that basis for a whole variety of reasons. I mean, starting with the fact that the Supreme Court is never going to go there. Now, that doesn't answer several problematic points. The first of these is whether it is not the case that the Commerce Clause has to be exclusive over some range. And then you're just debating, you know, what exactly is that range? And there, I think, is the real conceptual problem. You have to decide, how do you justify that range? Where does it come from? There are suggestions in some modern cases, interestingly enough, that go that route. There are some internet cases in the lower courts where judges have in fact held, pursuant to, I mean, arguments that were brought to them by the plaintiffs. Look, the internet it's inherently national, right? It's almost like patents. Either the patent holds good everywhere or nowhere. You can't allow a single state to defect from that kind of a regime. And the same is true about certain kinds of information markets. The credit markets work like that, right? Either we have a credit reporting system that works, or else everybody defects and has their own privacy rules, in which case the credits dry up. So it's one or the other, and on those grounds, for those kinds of economic reasons, you'd say it's exclusive. But those arguments are devilishly difficult. Yeah?
Doesn't Wickard versus Filburn provide you with some presidential authority, Supreme Court, for your exclusivity principle?
Run that by me again, because I think it's actually the other way around. And go ahead.
Well, the argument would be that all commerce is interstate, or has
oh, I get it. Sorry, I misunderstood the question. No, because what it doesn't do is, I mean, the exclusivity, again, the exclusivity has to mean that there's something on both sides of the line, right? And what Wickard says is there's nothing on the other side of the line. Here's an interesting, and this is the sort of conceptual problem, and it's really a deep conceptual problem. The distinctions between internal commerce and external commerce, between direct effects and indirect effects on interstate commerce, survived Wickard versus Filburn in dormant Commerce Clause cases for a very, very long time. I mean, you get cases, right? H.P. Hood, which is sort of one of these cases that everyone likes to celebrate because it's Justice Jackson's sort of paean to, you know, we must sink and swim together. It's one national market. At least it's one national market until the federal government gets around to cartelizing it, which was the true holding of the decision. To Felix Frankfurt, I mean, in 1959, there's a big decision called Portland Cement, not the APA case, but the tax Portland Cement case, which deals with the state taxation of interstate business income. And the question they confronted in the case, what exactly is interstate business income and what is in-state business income for tax purposes? The distinction survived. And you look at these decisions and opinions, Have you guys read Wickard versus Filbert? It doesn't matter, right? The distinctions there survive. The question is, why did they survive? And I think the answer is something like this. We know that state laws with discriminatory effects are barred by the Dormant Commerce Clause. But that broad statement can't possibly be right, because there are tons of state laws that regulate sort of humdrum internal affairs that have some sort of incidental spillover effects into other jurisdictions, which sometimes may marginally make out-of-state economic actors worse off, right? So you have to have some way of distinguishing the kinds of effects that count in either because of their scope or because of their scope and magnitude, or because they're so direct, versus the effects that are sort of trivial. I mean, no externalities cannot literally mean no externalities. Signed, Gordon Tullock. Right? So, and once you're at that point and you say, no, there are some effects that count and some effects that don't count, you're then, next thing you know, you're comparing them to the relevance and purpose of the local regulation, and you're into sort of Pike versus Bruce Church, which is the direct-indirect distinction in thin disguise. There is no getting away from that problem, and so long as you think in those terms, you have to think in terms of, no, I mean, in however attenuated the link is, those are the remnants of the exclusivity doctrine, and that is why the hard conceptual problem is, can you have an anti-discrimination norm that's completely divorced from any kind of exclusivity doctrine? I'm inclined to think that the answer is no. There is some literature on this point, but it's all very, very confused, just as confused as my remarks just were.
Michael, e-commerce faces barriers from state laws that are not always discriminatory or blatantly protectionist. And one example I know you know about is the consumer protection laws that show up in the states for things like spam and security breach notification laws. These are irresistible to a state legislator. You don't even have to send them a birthday card, and they'll rush to pass laws like this that they can brag about at election time. But as you know, they affect the interstate commerce, and they create a tremendous patchwork problem. So industry is left with running to Congress and begging for federal preemption. And that is a very difficult bargain to achieve. Congress will expand and do more than just preempt, and they'll typically extract a pound of flesh from industry when it seeks this. And so my question to you is, should industry be going to the courts instead of Congress for preemption of patchwork, like the Quill case was? And what would be the best path to take?
My decisive answer is, it all depends. I mean, you know, it depends on what the state legislation is, what exactly it regulates, what exactly is at issue. Again, one of the great difficulties in precisely that arena is that the non-discrimination, it's probably the best example of an area where anti-discrimination alone doesn't seem to do the job that you want it to do. That's the great glitch. That's why hence the temptation in some of the lower court opinions, American Booksellers Association, I mentioned that earlier, to say no, it's exclusive, and we don't really care about the discriminatory effect here. There's a very ingenious article by Max Stern's, 2002, William and Mary, which goes to these kinds of cases and conceptualizes them as state defections from equilibria, and the reason why the Supreme Court has at times proven willing to mow down those kinds of state laws is that they create quasi-rents in the states that defect. And that's the most ingenious part of Max's article. Its genius is to make those cases sound like discrimination, which in a conventional sense they really aren't. Right, but it's a very, very useful way, and I think at bottom, I mean, he's onto something very important there. The long and short of it is, I mean, I don't have a very good answer to those kinds of problems. I'll say one more word about these consumer protection laws. To my mind, The big problems there have to do not with discrimination, but with extraterritoriality, which is something I haven't spoken about at all. The Dormant Commerce Clause is supposed to have an extraterritoriality prong, which I haven't spoken about either. On that score, I would be extremely leery, I mean, to sort of couch these cases as Dormant Commerce Clause cases that violate the Dormant Commerce Clause rule against extraterritoriality, because that claim always loses. The Supreme Court is just not very willing to go there. You really have to go to sort of extreme examples. Price affirmation statutes are like that, right? We directly regulate transactions that are entirely in sister states. That you can't do. Short of that, the extraterritorial effects, even if they're hugely problematic, really don't matter. Pharma is the last case, the Pharma versus Concannon, last case that was decided like that. And there's a real danger in that litigation market because, even among very good lawyers I know, you can see that the corporate clients get nervous and they yell and, they were exposed to these kinds of things and it's extraterritorial legislation. And then as a lawyer, you have to calm them down and say, that isn't worth a damn. I mean, at least not under the Dormant Commerce Clause. We have to think of something else here. All clear as sunlight, right?
Wait, one more.
We would like to thank you for participating today and for your remarks,
nice.
and give you a commemorative compass from the Mercatus Center. And I'll read the inscription inside, which is from Leonardo da Vinci. He who loves practice without theory is like the sailor who boards ship without a rudder and compass and never knows where he may cast.
Thank you so much.
Thank you so
Aaron,
much.
thanks a bunch. And thank you all.
Thank you all. I just have a few administrative remarks. We have put some copies of the Winter 2005 Journal of Law, Economics, and Policy on the bookshelf as you walk out. Feel free to grab a copy, and if we run out, we have more, so we can get you an extra. And also, if you did request parking from me, I do have your validation stickers downstairs, so just come see me at the registration desk. Other than that, we can head back down to room 329.